Now to that big announcement from the U.S. Supreme Court today. The justices will now decide whether Donald Trump can be kept off the Colorado primary ballot.
And all new tonight, former President Trump reacting to that decision at a campaign event in Iowa.
The Supreme Court is taking the case from Colorado. When you are a Republican judge and you're appointed by, let's say, Trump, they go out of their way to hurt you so that they can show that they have been fair. I just hope that they're going to be fair because, you know, the other side plays the ref.
Denver 7 attorney and reporter Jessica Crawford joins us live from the newsroom now. Now, Jessica, you spoke with Secretary of State Jena Griswold shortly after the announcement was made.
Yes, I did. And Griswold says that Colorado's 2024 presidential primary ballot is certified. So as of now, Trump will be on Colorado's ballot. Now, the Supreme Court could make the ultimate decision on whether he'll stay on ballots across the country. To be or not to be on the ballot, the Supreme Court has agreed to hear arguments on whether former President Donald Trump can appear on the 2024 ballot if he engaged in the January 6th insurrection.
I think it's a good thing that the U.S. Supreme Court is taking up the case. Ultimately, I think Americans deserve clarity whether someone who engages in an insurrection can then serve in the highest office in this nation again.
Denver 7 spoke with Colorado Secretary of State Jena Griswold immediately following the Supreme Court's decision to take up the case. She sent out this tweet just after 4 p.m. on January 5th saying Colorado's 2024 presidential primary ballot is certified. The United States Supreme Court has accepted the case and Donald Trump will appear on the ballot as a result. The Supreme Court will hear oral arguments on February 8th, and they're expected to make a decision on whether Trump can remain on the ballots before Super Tuesday on March 5th. That's when the largest number of delegates are up for grabs in a single day, and that includes Colorado. Griswold saying the path to this point has been a difficult one.
Since this case was initially filed in September, I have seen an uptick of death threats. But I will not be intimidated. I, of course, will oversee our elections to make sure that they're great, just like normal.
But legal scholars are not shocked at all that the Supreme Court decided to take up this case.
My initial reaction is that I'm completely not surprised. This was bound to happen.
DU Stern College of Law professor Ian Farrell saying there are multiple outcomes for this case. The Supreme Court could decide Trump stays on the ballot. They could decide he should be off the ballot. Or they could decide it's not their decision at all.
If they apply the political question doctrine, they're effectively saying this is not a legal question for the courts to decide. This is ultimately a political question for Congress to decide.
And this decision is historic. The High Court is considering this issue for the first time ever. And the amendment that they are making the decision on was adopted back in 1868 following the Civil War. In the newsroom, I'm Jessica Crawford, Denver 7.
Thank you, Jessica. Digging deeper here, Maine is the only other state besides Colorado so far that has ruled that Trump is ineligible to appear on the ballot. However, there are pending challenges in more than 30 states. Ruling on challenges in Michigan and Minnesota, the state Supreme Courts in both of those states have ruled that Trump can appear on the ballots there.
And the High Court's involvement is a political powder keg. The last time the U.S. Supreme Court was directly involved in the outcome of a presidential election, of course, the 2000 race between George W. Bush and Al Gore, who can forget the hanging Chad. 23 years ago, the Supreme Court stepped in and ended a ballot recount in Florida that effectively delivered the election to Bush. That case is still argued over to this day. And the country, of course, far more politically divided now than it was then.
Going in depth, calls are growing for Supreme Court Justice Clarence Thomas to recuse himself from this case. A group of 8 Democratic House representatives sent a letter to him this week demanding he recuse himself. In it, they argue that Thomas cannot be impartial, considering his wife's past efforts to overturn the 2020 election. Ginny Thomas helped plan and attend the Stop the Steal rally in Washington, D.C., which directly preceded the January 6th Capitol riot. The letter also suggests the Thomases have a financial stake in Trump returning to the White House, which constitutes a conflict of interest. Thomas has recused himself in the past from one January 6th case involving Trump advisor and former CU Boulder scholar John Eastman. However, he has faced scrutiny for refusing to step away from other January 6th related cases.